everyone, welcome to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. How maritime law works in the United States. Admiralty law or maritime law is a body of law that governs nautical issues and private maritime disputes. Admiralty law consists of both Admiralty law consists of both domestic law on maritime activities and private international law governing the relationship between private parties operating or using ocean-going ships. While each legal jurisdiction usually has its legislation governing maritime matters, the international nature of the topic and the need for uniformity has, since 1900, led to considerable international maritime law development, including numerous multilateral treaties. We can use the term of maritime law and admiralty law interchangeably. The maritime law of the United States is different in several interesting aspects from that of the other leading maritime nations. The history and nature of these differences have been frequently examined, but many important changes have occurred as the law grows and changes under the impetus of our great new American maritime activity. It is therefore opportune to re-examine some of the more important points, and especially those which have developed and changed during the past 20 or 30 years. Maritime or admiralty lawyers are specialized lawyers that provide legal counsel and representation to those involved in the business of shipping and its related areas. The maritime law covers many topics. These include: first, right of seamen, longshoremen, and passengers; second, collisions and elisions; third, responsibility for cargo loss and or damage; fourth, bill of lading disputes; fifth, marine pollution; sixth, charter party law; seven, towage and pilotage; eight, maritime liens and attachment; 9. Marine insurance disputes; 10. General average; and 11. Salvage and fines, among other topics. Maritime law used to apply only to American waters within the ebb and flow of the tide. However, it now covers any waters navigable within the United States for interstate or foreign commerce. Admiralty jurisdiction also includes some maritime matters not involving interstate commerce, for example, recreational boating. The courts of United States and Congress strive to create a uniform body of maritime law. The United States federal courts have original jurisdiction over admiralty and maritime claims. It arises out of Article 3, Section 2 of the United States Constitution. Therefore, maritime cases are primarily heard in the federal courts, and the federal maritime law applies. The strong revival of shipping, both under the American flag and under 40 or 50 foreign flags, might give this survey a practical value. The development of admiralty jurisdiction and maritime law has been the subject of many studies by note. American legal authors and its history has been traced by learned judges in their opinions. Earliest was Judge B, who presided over the federal court in Charleston, South Carolina in the years 1790 until 1812. His opinions carefully state the European source from which he derived the principle. Maritime law in the United States developed from English maritime law and the maritime laws of other or older seafaring nations. It is an old body of law dating back to the earliest days of navigation and commerce. Maritime law is created in different ways. First, maritime law is created by judicial opinions rendered by the federal courts. These cases are not only binding upon the parties, but also establish a common or general maritime law that acts as a judicial precedent for all cases to follow. Second, maritime law is also created by legislation routinely at the federal level by United States Congress. For example, the United States Carriage of Goods by Sea Act and the Jones Act. Third, maritime law is also created via international conventions, for example, the Civil Liability Convention, which is an international convention concerning liabilities arising out of marine pollution caused by a ship. Fourth, maritime law is also created by the decision of marine arbitration panels that create a body of commercial law or usually when resolving counterparty disputes. Maritime law is different from the law of the sea. Maritime law is a private body Maritime law is a private body of law primarily governing the relationships between people and companies. It is the body of law that governs the shipping business. The law of the sea is a body of public international law. It is the body of law that primarily regulates the relationship between nations. It addresses crucial questions that concern a nation's sovereignty over its territorial sea and economic zones, the freedom of the sea, the law of piracy, among many other topics. Maritime or admiralty lawyers specialize in maritime law. However, there is no special law school for this. In the United States, a person becomes a maritime lawyer by graduating from a law school and by appearing a state bar exam, like any other lawyer. That person may then to go work for a law firm that has clients that are in shipping or shipping related files. The cases the firm handles will primarily be maritime. Maritime lawyers will also work for P&I clubs, hull insurers, and be in-house counsel to ship-owning companies. While most maritime lawyers concentrate their practices in the maritime law, they are free to handle non-maritime cases as well and often do. The United States American operates under common law and statute law, or which by the way includes the Constitution. Maritime law is a part of the law of the United States America, though it's not probable for most citizens to enter into contact with it. Be extremely wary of people who think they have found a fantastic legal argument to be free from all taxation and from all state power. That legal argument is always legal quackery. However, I would like to mention that it's not completely exclude that example, a major tax law is unconstitutional for some reason. I have written myself about the possibility that Belgium has been using the wrong civil code since 1831, which is a very far-reaching conclusion and could easily veer into legal quackery if it's not researched in great depth. Far-reaching legal conclusions are not necessarily legal quackery. There are new few law schools in the United States that offer more maritime law courses than others, such as Tulane University Law School in New Orleans. Tulane even offers a post-GED program in the maritime law. These are great programs, however, it is not necessary to attend them to practice maritime law. Maritime law firms in the United States America are located primarily in the port cities, New York, Houston, New Orleans, Seattle, and etc. There is a huge presence in London and elsewhere. Many Many maritime lawyers have experience in the shipping business and attend a maritime college, but not all. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.